The Judiciary of India. India's independent union judicial system began under the British, and its concepts and procedures resemble those of Anglo-Saxon countries. The Supreme Court of India consists of the Chief Justice and 33 Associate Justices, all appointed by the President on the advice of the Chief Justice of India. The jury trials were abolished in India in the early 1960s after the famous case of K.M. Nanavati vs. State of Maharashtra, for reasons of being vulnerable to media and public pressure, as well as to being misled. Unlike its United States counterpart, the Indian justice system consists of a unitary system at both state and union level. The judiciary consists of the Supreme Court of India, high courts at the state level, and district courts and session courts at the district level. The Supreme Court of India. The Supreme Court of India is situated in New Delhi, the capital region of India. The Supreme Court is the highest judicial forum and final court of appeal under the Constitution of India, the highest constitutional court with the power of constitutional review. Consisting of the Chief Justice of India and 33 sanctioned other judges, it has extensive powers in the form of original, appellate, and advisory jurisdictions. As the final court of appeal of the country, the Supreme Court takes up appeals primarily against verdicts of the high courts of various states of the Union and other courts of tribunals. It safeguards fundamental rights of citizens and settles disputes between various governments in the country. As an advisory court, it hears matters which may specifically be referred to it under the Constitution by the President. It also may take cognizance of matters on its own or suo motu without anyone drawing its attention to them. The law declared by the Supreme Court becomes binding on all courts within India and also by the union and state governments. Per Article 142, it is the duty of the President to enforce the decrees of the Supreme Court. In addition, Article 32 of the Constitution gives an extensive original jurisdiction to the Supreme Court in regard to enforcing fundamental rights. The Supreme Court is empowered to issue directions, orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari to enforce them. The Supreme Court has been conferred with power to direct transfer of any civil or criminal case from one state high court to another state high court, or from a court subordinate to another state high court and the Supreme Court. Although the proceedings in the Supreme Court arise out of the judgment or orders made by the subordinate courts, of late the Supreme Court has started entertaining matters in which interest of the public at large is involved. This may be done by any individual or group of persons, either by filing a written petition at the filing counter of the court, or by addressing a letter to the Chief Justice of India highlighting the questions of public importance for redress. These are known as public interest litigations.